Uh, Good morning, everybody, again. Good morning, Ndate Chauke. We adjourned to wait for you. But I'm speaking to you through your counsel.
Madam Chair, Mr. Chauke did arrive 25 minutes after the adjournment. He tells me that he had traffic problems driving from Johannesburg, made worse because it's raining today. He says he left home at 8. He would have made it by 9 if it was a normal day. Maybe next time he should leave home at 7:30. So
At 6:30.
But to conclude, on his behalf and on behalf of our team, we sincerely apologize.
Thank you, Council. Let us try, all of us, to stick to time. All of us have traveling challenges, and Ndate Chauke, as your counsel indicated earlier, it is in your interest that you are here physically when we start every morning. I do appreciate that some of you are traveling from Johannesburg. I used to work in Johannesburg and leave Pretoria at 5 o'clock every morning. It is doable. You may begin, Advocate Mhlamunyane.
Thank you, Madam Chair. Advocate Batohi,
I will remind you once again, Counsel, Advocate Batohi, that you are still under oath.
Thank you, Chair.
My sister, Advocate Baloyi, seemed to be complaining about the heat. Are you all feeling this heat?
I've been complaining since day one.
Thank you. My PA, a researcher, is telling me that they are aware that there's a problem with this heat and cold, and they are working on the air conditioning, but they can do it physically when we adjourn so that they can get into the seat chamber and fix what they need to fix. So when we adjourn for tea, they will come and try to address this problem. That is why hearings under a tree are always better. Council, you may proceed.
Thank you, Madam Chair. Before I proceed with the evidence of Advocate Chauke, Advocate Batohi, my apologies. I need to mention to you, Madam Chair, and your two sisters, that the issue of exhibits is being attended to by Advocate Lekgetho, but then she has to start from the beginning and refer to the transcript so that she could get the exact number of documents that have been referred to. She has started with the process, and my proposal is that any document that is being referred to here will be an exhibit without
will be referred to as an exhibit without it being numbered, and the numbering will be dealt with later on, because she's afraid that if we start, say, the next document is 15, and after she had gone through the transcript, it may change and it may cause a confusion, and we ask for that indulgence so that it can be properly done. And at the end of Advocate Batohi's evidence, I hope it shall have been done and properly indexed, and it will be handed up to the panel.
Thank you, Counsel.
Thank you, Madam Chair. Advocate,
As long as when Advocate Nkabinde starts with cross-examining the witness, that document will be handed to all of us so that we use the naming as per list.
I'll try my best to have it ready then. Advocate Batohi, let us recap. You remember yesterday that we were dealing with applications for racketeering and how indictments are done, and dealt with prosecution memoranda. Now we will proceed from where we left off yesterday, and today, Madam Chair and your two sisters, we will begin with what is referred to as centralization. And I must mention that centralization, as evidence will be given, will have an impact on paragraphs 3.1, 3.1.1, 3.1.1.1, 3.1.1.2 of the terms of reference. Having said so, I refer you to LO3, bundle LO3, to page 843 of that bundle. LO00843, Madam Chair, where you will find an application for centralization of charges in terms of Section 111 of Act 51 of 1977. You may then proceed to talk to this document.
Thank you, Counsel. To recap, as I mentioned yesterday, centralization is a process that the affected DPPs would engage in where a case has offenses committed in different jurisdictions. The DPP of the relevant jurisdictions would then consult and agree to the case being heard, generally for convenience, in one of the jurisdictions. They would then, having consulted, apply to the National Director for the case to be centralized in one of the jurisdictions. The document referred to LO000843 is a memorandum dated 15 August 2012. It will be noted that this is the same day of the application for the racketeering authorization that we dealt with yesterday. It's a memorandum from Advocate Chauke to Advocate Njiba. And I'm not sure if I'm required to read it, but it basically sets out the fact that if you look at paragraph 2, most of the predicate offences are committed in KwaZulu-Natal, but there's one matter that is in the Northwest jurisdiction. Paragraph 2 refers to Rustenburg, which is in the Northwest jurisdiction. They then go on to give a summary of the cases, and then from paragraph 12, the charges are set out.
Advocate Patohi, allow me to interpose you with, I think it is imperative that it should be read into the record.
I'll do so now.
What is she to read into the record?
To read the application, Madam Chair.
So I will read the document. The subject line, well, as I mentioned, it is from Advocate Chauke to Advocate Chiba, who was acting National Director at the time. Dated 15 August 2012, subject application for centralization of charges in terms of Section 111 of Act 51 of 1977, the State versus Boyson, Johan Wessel, and 4 others, Rustenburg CAS 1090/09/2009. Paragraph 1. The above-mentioned accused will be charged together with other persons of racketeering offences in terms of the Prevention of Organised Crime Act 121 of 1998 in the High Court for the Division of KwaZulu-Natal. They were involved in an enterprise, the business of which was to kill suspected criminals, and received monetary rewards and/or certificates of excellence from the state for solving violent crime. Most of the predicate offences in pursuit of the aims of the enterprise were committed in the province of KwaZulu-Natal. There is one docket, Rustenburg CAS 1090/09/2009, where Padiachi, Gonesegran, Mostert, Paul Jonathan, and Eva Neville, who are police officers based at the Organised Crime Unit, Cato Manor, Durban, in the KwaZulu-Natal province, traveled to Rustenburg, where they killed Sifiso Ndimande. Paragraph 3, according to the accused, Sifiso Ndimande was sought amongst other crimes in the Beki Temba CAS 113/1/2009, wherein Nkosi Wellington Zondo was killed. Allegedly, Nkosi Zondi, not Zondo. Allegedly, Nkosi Zondi was killed because he was the former police informer in the case where Magojela Timson Ndimande and Sibosiso Temba were killed. Magojela Timson Ndimande and Sibosiso Tembe were killed because they were suspected of playing a role in the killing of Superintendent Zitembe Tonko, who was a police officer investigating taxi-related violence in KwaZulu-Natal. Paragraph 6, the killing of Sifiso Ndimande, Magojela Timson Ndimande, and Sibosiso Temba are among the predicate offences committed by Padiachi Gonesegran, Mostert Paul Jonathan, and Eva Neville, who are accused 2, 4, and 6 in the racketeering indictment. The evidence in the killing of Sifiso Ndimande is briefly that Mostert and Padiachi kicked, opened, and entered the house of the deceased. As they entered the house, Mostert and Padiachi fired shots and killed the deceased. The deceased died at the scene. Eva Neville took over the scene. Boyson Johan Wessel and Olivier Willem Cornelius are charged as managers of the enterprise. Paragraph 8, as their modus operandi, the accused placed a firearm next to the body of the deceased to create an impression that their lives were in danger when effecting arrest. 9, the Director of Public Prosecutions in Northwest declined to prosecute on this docket. They instructed an inquest to be held. Thus, this matter is currently on the roll for a formal inquest. Their reference number is 9/2/4/1-32/11B. Paragraph 10, the Office of the Director of Public Prosecutions Northwest did not have the benefit of the accused's modus operandi and factual cause of the killing. 11, the prosecution team intends to arraign Padiachi Gonesegrin, Mostert, Paul, Jonathan, and Eva Neville with racketeering offences, together with 26 other accused. They are also charged with 116 counts in the KwaZulu-Natal Regional Division. Paragraph 12, the prosecution team prefers the following charges in respect of the Rustenburg docket: housebreaking with intent to commit murder, and murder read with Section 51.1 of Act 105 of 1977 and Section 155.1 of Act 51 of 1977. Contravention of Section 3, read with Sections 1, 103, 117, 121A, and 121, read with Schedule 4 of the Firearms Control Act 60 of 2000, and further read with Section 250 of the Criminal Procedure Act 51 of 1977, the charge being unlawful possession of firearm. Contravention of Section 90, read with Section 1, 103, 117, 121A, and 121, read with Schedule 4 of the Firearms Control Act 60 of 2000, further read with Section 250 of Criminal Procedure Act 51 of 1977, unlawful possession of ammunition. Defeating or obstructing the course of justice. Paragraph 13. It is desirable and in the interest of justice that all the matters be held in one forum, which should be the High Court for KwaZulu-Natal. The reasons for this are the following. 13.1. The separation of trial forums will lose the similar fact evidence. 13.2. All the accused are based in KwaZulu-Natal, therefore centralization will be cost efficient. 13.3. The offences in Rustenburg were furthering the aims and objectives of the enterprise operating in KwaZulu-Natal. It is thus prudent for proper functioning of the administration of justice that these offences are tried together in a single trial. 13.4. The motive for the killing is closely connected to the other killings in KwaZulu-Natal. The chain of the killings, as well as the modus operandi, will provide the court with a complete picture of the manner the enterprise operated. Paragraph 14. In light of the above, separate trials would be prejudicial to the accused, witnesses, and proper administration of justice. 15. The following documents are attached. A draft indictment in terms of Section 101, 111 of Act 51 of 1977. B, a copy of the indictment. C, a consent letter from the DPP Northwest. Paragraph 16, although Boyson and Olivier were not present on the crime scene in Rustenburg, they have been added in this application by virtue of their management of the activities of the enterprise. Signed, M.A. Chauke, Director of Public Prosecutions. So it's a spelling error, South Gauteng High Court, Johannesburg.
Advocate Batohi, this document is comprehensive. This application for centralization of the charges is a comprehensive document.
That's correct.
Does it
Sets out the
suggest,
charge.
therefore, that Advocate Chauke has read the docket? Because he's referring to
It would suggest that he is aware of the facts of this matter. He Pardon
must
me?
have deciphered from the docket.
I don't
Dockets.
want to make that assumption, but what I can say is that he has a good knowledge of the facts of this matter.
Go to the next page, LO 00847. You'll see that there is a direction in terms of Section 111 of Act 51 of 1977. This is the same document that is being referred to in paragraph 15A of the application.
Yes, a draft direction, 15A, that's correct.
Which is signed. If you go to the next page, this direction ends on the next page, LO 00848, not so.
That is correct.
It's referred to as a draft direction, but it would appear that it was signed in Pretoria on the 17th day of August 2012.
That is correct. I should add that when documents are submitted to the National Director, they are often couched in the way of a draft. In the event the NDPP wants to amend it in any way, then it can be done.
This was done, and it was signed by Advocate N. Jiba. Acting National Director of Public Prosecutions.
That is correct. On the 17th of August, 2012.
Go to the next page, following that one, 849-00849.
What is the page?
LO 00849, Madam Chair. It's an internal memo from Advocate Amos Singh. Do you see that?
I do, dated 16 August, 2012.
Before we proceed, lest I forget, Madam Chair, I ask that this document, the application for centralization of charges, the one that we dealt with, be marked as an exhibit. It will later be given a number. And I apply that it be handed up as an exhibit.
I beg your pardon, Council. I beg your pardon.
I'm saying, lest I forget, we dealt with the application for centralization. We're
Yes.
done with that, and I'm asking that it be marked as an exhibit, although it will not have a number at the moment. But at the appropriate time, it will be accorded a number, and I ask that it be handed up as an exhibit.
Might I suggest rather that you don't place these documents now as exhibits without numbers? Have a comprehensive document presented to us at the end of this testimony before cross-examination. And Advocate Batoyi will then confirm the correctness of those documents. I suppose that when you prepare that dossier, it will reflect what it is in the column, and the next column will reflect the exhibit number. Then she can confirm those documents. You can hand up the document. Otherwise, you're going to do things piecemeal here. Thank you.
Thank you, Madam Chair. I'll deal with it in the manner proposed by yourself. Go to 849. Let's return to 849, 00849, Advocate Batoyi. The document will be appropriately marked as an exhibit later on. It's an internal memorandum from Advocate Amos Singh. Would you read that document into the record? Content of the document into the record.
It's an internal memorandum from Advocate Amos Singh, Head Special Projects Division, to Advocate Njiba, Acting National Director of Public Prosecutions, subject the State versus Boyson, Johan Wessels and others, date 16 August 2012. Subject line is application for authorization in terms of Section 2(4) of the Prevention of Organized Crime Act, 121 of 1998, in brackets the Act, an application for centralization directive in terms of Section 111 of Act 51 of 1977. Dear Advocate Jiba, attached, please find a letter from the Acting Director of Public Prosecutions, KZN, incorporating a proposed indictment, prosecution memorandum, draft authorizations in terms of Section 21E and 21F of the Act, an application for centralization and draft centralization directive. I've perused the application and have on several occasions met with the prosecution team in insisting and guiding them on the principles involved in the offense of racketeering. In the process, the available evidence was also perused. The concept of the enterprise in this matter was also fully dealt with, and I support the defining of the enterprise as being the serious violent crime section, in brackets SVC, of Cato Manor, which, being a unit of the SAPS, is a legal entity for the purposes of the definition of enterprise as defined in Section 1 of the Act. Furthermore, the section formed part of the Durban Organised Crime Unit and as such was part of the provincial organised crime structures of the SAPS in KZN under the command of the Provincial Commander, Organised Crime, and subsequently the head of the DPCI as from 2010. The offences charged also fully comply with the definition of pattern of racketeering activities as there are more than 2 racketeering events. The accused listed as managers are the group commanders of the section commander, and the provincial commander, Organised Crime, KZN. It is submitted that all these complies with being managers as was determined in De Vries matter at 388. Quote, the first requirement for a conviction under count 1 is that the accused must have managed the operations or activities of the enterprise. The Concise Oxford Dictionary, 10th edition, defines manage in quotes as, open quotes, be in charge of, supervise, administer, and regulate, or maintain control or influence over, open quotes, a person or animal, close quotes, open brackets, close brackets after animal, close quotations. I have similarly perused the application for centralization of the event that occurred in Rustenburg in the area of the jurisdiction of the DPP Northwest. This is indeed one of the racketeering events, and it would be in the interest of justice to charge this event together with the rest of the racketeering event in order to have a holistic picture of the activities of the enterprise. It is consequently recommended that the authorizations for racketeering prosecution and centralization directive as requested be granted. Kind regards, Advocate A. Mosing, Head Special Projects Division, Office of the NDPP. It's unsigned.
I will later ask that it be handed up as an exhibit. Let's proceed to the next page. The one that follows after that should be 852. It's authorization in terms of, the heading says authorization in terms of section 2.4. Please read it into the record.
This is an authorization in terms of Section 2.4 of the Prevention of Organized Crime Act, the state versus Boysen Johan Wessel, and there are 18 other accused reflected on this document. I'm not sure that I need to read them all out.
You don't have to.
And then
Proceed to the next paragraph.
I, Nomkobo Jiba, Acting Director of Public Prosecutions, South Africa, do hereby in terms of Section 2.4 read with Sections 1 and 2 of the Prevention of Organized Crime Act number 121 of 1988, authorize the institution of prosecution against the above-mentioned accused for contravention of Section 21E of the Prevention of Organized Crime Act 121 of 1998, committed during the period 2008 to 2011, given under my hand at Pretoria on the 17th day of August 2012, signed Advocate Nomkobo Jiba, Acting National Director of Public Prosecutions, Republic of South Africa.
Go to the next page, 00853.
So the impact of the previous document that I signed is that the National Director has authorized this racketeering prosecution.
Yes.
The next document, as you mentioned, authorization in terms of Section 2.4 of the Prevention of Organized Crime Act number 121 of 1998, the state versus Boysen Johan Wessel and 4 others listed in the document. I, Nomkobo Jiba, Acting National Director of Public Prosecutions, South Africa, do hereby in terms of Section 2.4 read with Sections 1 and 2 of the Prevention of Organized Crime Act number 121 of 1998, authorize the prosecution against the above-mentioned accused for contravention of Section 21F of the Prevention of Organized Crime Act number 121 of 1998, committed during the period of 2008 to 2011, given under my hand at Pretoria on the 17th day of August 2012, signed Advocate Nomkobo Jiba, Acting National Director of Public Prosecutions, Republic of South Africa.
Let's then take it. Go back to.
Might I clarify something, Council? In respect of LO 00852, the first authorization, the case against Boysons and 18 others, is it the same case number or different case numbers? You can find out,
Let me find out as to whether
perhaps Advocate Batoyi can assist
can
us.
assist in that regard.
Chairperson, I'll try. I'm not sure if it's the same case numbers, but what I can say is that the first one, 00852, is in terms of section 21E, which is just above the date. You'll see section 21E of the Prevention of Organized Crime Act. And the second one, you'd see it is an authorization in terms of section 21F of the Prevention of Organized Crime Act. Now, if my memory serves me correctly, 21F relates to the management contraventions, offenses relating to management, and E refers to offenses relating to participation in the enterprise.
And the heading refers to 2 subsection 4.
That is correct. They all part of section 2.4, but one is E and one is F. 241.
Yes.
Well, it says 2.4, but it says section 2.1E. So I'm a little bit confused about that myself.
Let me assist if Madam Chair would allow me for now.
Yes, you may, sir.
Remember what section 2 subsection 4 says.
Yes, if I recall, it's the
Yes.
authorization by the National Director, if I'm correct.
Yes, that any person, if you, can you read it into the record
Yes,
for purposes of
POCA.
yes, of
Do
POCA.
I have a copy of POCA in front of me? I think I do. If you can help me, do we have it in front of me? I think there was a copy that was handed. I'm not sure where it is.
You may assist, Madam, you may assist Advocate Batoyi with.
Thank you very much, Chairperson. Where is it? No, I think there's another copy there. We can grab that. Okay, thank you, thank you. I don't know where it is. Do I have a copy of book? I can give you a copy.
Madam Chair, I have a hard copy which I can lend.
But my question was simple. My question was whether these people who appear under authorization in terms of section 2.4, followed by section 2.1E, the first one, are whether charged under in terms of this one case number, or are there different dockets in relation to these people? You understand my question, Council?
Yes, I do. I just want to.
Advocate Batoyi, do you understand my question?
I'm not clear.
My
Chairperson.
question is, when you look at page LO00852, you have accused 1 up to 19. My question is whether these people are charged under one case number or one docket, or whether there are different dockets in relation to these accused people.
I can't answer that question. I do not know, Chairperson.
You don't know. I asked that question because mention has been made earlier that there was a plethora of dockets in relation to the Katomena matter. That is why I need clarity in relation to that question, and also in relation to your 2F 21F, if you can ascertain whether these 5 people were charged under the same case number, meaning that there would have been one case docket. You can ascertain that later, Council, and just flag it and let me know.
I'll do that later. Thank you, Madam Chair.
You may proceed, sir.
Thank you. To tie it up, Advocate Patohi, I'm referring you back to Advocate Jiba's authorization in terms of Section 21E of POCA on page 852. And the next page, her authorization in terms of Section 21F. On page 853.
Just for clarification, the authorizations are in terms of section 2.4, but the charges relate to contraventions of section 2.1E in the first document and 2.1F in the second document.
Let's clarify it. So there were 2 authorizations.
That's correct.
One in terms of section 2.1 subparagraph E, the other in terms of section 2.1 subparagraph F.
The first one is for contraventions of section 2.1E, and the second one is for contraventions in terms of section 2.1F of POCA.
And both of them were signed by Advocate Jiba, the acting National Director of Public Prosecutions, on the same day, 17th August 2012.
That's correct.
Let us then proceed to the next page, LO00854, wherein you see a document there dated 2nd August 2012, addressed to Advocate M.A. Chauke. It's from Advocate J.J. Smith, SC, the DPP Mabatu. That we'll see on the next page, 855. But for now, I'll ask you to read this document into the record, and will later ask that it be marked as an exhibit.
So LO000854 is a letter on the letterhead of the National Prosecuting Service, Director of Public Prosecutions Northwest. It's dated 2nd of August 2012. It's addressed to Advocate M.A. Chauke, Director of Public Prosecutions, South Gauteng Provincial Division, Private Bag X8, Johannesburg 2000. Dear colleague, subject line, consent to consolidation of charges in terms of section 111 of Act 51 of 1977, State versus Padiachi and others, Cato Manor Project, Rustenburg, CAS 1097/09/2009. I have perused your application for centralization of charges arising out of Rustenburg CAS 1097/09/2009 and the copy of the indictment which took place within my area of jurisdiction. I have no objection that the charges mentioned in counts 31 to 34, namely count 31, housebreaking with intent to commit murder and murder, count 32, contravention of section 3 of the Firearms Control Act 60 of 2000, count 38, contravention of section 90 of the Firearms Control Act 60 of 2000, and count 34, defeating or obstructing the course of justice, be dealt with in a single trial, together with racketeering charges against all accused within the area of jurisdiction of the KwaZulu-Natal High Court against the following accused: Gonesegrin Padiachi, Paul Johan Mostert, Neville Eva. I am persuaded that it will be in the interest of justice to centralize the prosecution in terms of section 111 of the Criminal Procedure Act 51 of 1977 in the High Court for KwaZulu-Natal in one singular trial, in brackets on charges including racketeering in terms of the Poker Act 121 of 1998, close brackets. I accordingly hereby consent to the prosecution of all cases in the area of jurisdiction of the KwaZulu-Natal High Court. Kind regards, Advocate J.J. Smith, SC, DPP Mabato, and it appears to be signed by him. I do not know his signature, but it appears to be signed by him.
Advocate Batohi, let's pause for a moment and reflect on this document, the application for centralization of charges made by Advocate Chauke. The content of the document suggests that Advocate Chauke motivates for centralization. Is that correct?
That is correct.
How would you categorize that, the motivation?
Well, I would categorize, sorry. It is a decision to centralize matters between DPPs is a DPP's, is a prosecutorial decision. It's a decision made in a prosecution process in terms of where the trial should proceed. So I would categorize this as a prosecution decision taken in the context of a prosecution process.
Taken by whom?
It is taken by Advocate Chauke and Advocate Smith.
Counsel, following on my question earlier, it is apparent from the letter by Advocate Smith SC, Northwest, that the case number reflected on LO 00854, that is the letter, pertained to only 3 of the accused listed on page 1 LO 00852. That is the 19 accused persons. Number 2, Padayaki, Officer Padayaki. Number 4, Officer Mostert. And number 6, Officer Eva. And the case number in respect of these 3 accused persons is case 1097/09/2009. It then follows that we would need to have the case numbers applicable to the rest of the accused persons listed under LO 00852. That is the remaining of the 19 accused officers. Therefore, when you ascertain the case numbers applicable to those listed on that page, that is the first authorization, and in respect of the second authorization, you need to give us the case numbers. But you'll see that Eva is mentioned again under 21F, as she is also mentioned under 21E. Is it clear?
It's clear, Madam Chair. I will accept it.
It then also follows that there could be different dockets in respect of these accused persons. Thank you.
Chairperson, if I may try to assist in this regard, there were certainly, as you indicated, a number of dockets. And these were all various, mainly murder matters that were consolidated into the racketeering case. But as counsel had indicated, we'll get the CAS numbers for all of them.
It's important to get the answers for that so that when we deal with the dockets, we know exactly in respect of which officials or accused persons those dockets pertains, because it is critical for the determination of some of the issues before us.
Indeed. Madam Chair, we'll do that.
Thank you. Thank you.
Thank you, Madam Chair. Now, Advocate Patohi, were any of the offenses which were to be centralized in KZN committed within the jurisdiction of Advocate Chauke's area of operation, which will be South Gauteng?
No,
Was it proper for him, therefore, to motivate for centralization?
this discussion should have happened between the DPP and KZN, who has jurisdiction, and Advocate Smith.
I beg your pardon?
This discussion should have happened between the DPP and KZN and Advocate Smith.
The discussion to centralize.
That's correct. And the application should have also been made by the DPP and KZN.
May we look at the date on which Advocate Chauke was authorized or requested by the NDPP to coordinate the team? If you can remind me, when was he requested to coordinate the teams?
I can't
Okay,
recall
Isabel?
offhand, Chairperson. We need to be referred to a document.
It is there in the bundles.
It is there, Madam Chair. It's 8 March 2012, but I need to locate the document, locate the bundle.
You can just give me the date.
It's said to be 8 March 2012.
What page is that?
It must appear in his affidavit to.
Is it one of the documents that were filed of record by Advocate Batoi under the bundles of LOs?
Should be.
Advocate Chauke?
It should be, Madam Chair. Let me just.
It is important for me to get that date correct because it follows on the answer that Advocate Batoi has just given. Just want to make sure that I understand her answer in relation to that date.
Madam Chair, although I've been informed by my colleagues that the date is 8 March 2012,
Should we accept it? Look at the page from which you got that date.
yes, I'm not able to locate it immediately, but I've located Advocate Chauke's affidavit, which is LO1 in bundle LO1 on page 265, paragraph 57,
00265.
00265. He mentions Advocate Chauke in that paragraph 57, mentions it as at the end of April when he received a request from Advocate Jiba. But I'm made to believe that he might have been mistaken about that date, because in Musing's affidavit, Madam Chair, he says the date is the 8th. He attended a meeting, he's stating as the 8th of March 2012. So we are having two dates here. The
A
one
meeting for what?
he says he attended a meeting on or about 8 March at our offices with 3 members of the IPD.
I'm sorry to interpose. It appears that you don't understand my question. Advocate Jiba similarly requested Advocate Chauke to coordinate the team to go to KZN. There's a document in which this information is reflected. I would like to reflect on that. I do have that document. I can't remember where it is, but that document reflects a date on which Advocate Chauke was asked to coordinate the team. That's what I want to know. We will park it there so that we can reflect again, Council. And we will revert to this question that we have just asked Advocate Batoi. And just put your finger on your answer to the last question by Council, because I want to check on those dates. Then I will probably piggyback on that question and ascertain something from you. My sister is drawing volume 3 of the legal opinions to my attention. Probably the answer could be there, paragraph 7 and 8, but it's for a later time when you revert back to the question. LO 00706, volume 3, LO 00706. Thank you. You may proceed.
Thank you, Madam Chair. Advocate Patohi, I want you to go to page 00856 in LO3.
Are you dealing with the same issue or is another matter?
We are still dealing with centralization.
No. The pages that you've referred us to, volume 3, LO 007
00856.
856. Thank you.
Yes, but we are still on centralization, Madam Chair.
Thank you.
You will see that on that page, it's an application for centralization. And it came from Advocate Nokumashilo, who was the acting Director of Public Prosecutions. You'll remember that we already dealt with her tenure when she was appointed. Just read the document into the record.
Council, the entire document seems to be this identical to the previous one that I read into the record, but I'm happy to do so again because there might be minor changes.
No, for the sake of time, if it is identical,
It appears to be.
yeah, you don't have to read
You
it.
can check that.
Read the whole document.
The document is, it's a memorandum from the Director of Public Prosecutions, KwaZulu-Natal, Peter Maritzburg office. It's addressed to Advocate Njiba, the acting NDPP, from Advocate Noko Mashilo, acting DPP in KZN, dated 12th of August 2012. It appears to be the same contents as LO 00843. I haven't checked word for word. And it is an application for the subject line, application for centralization of charges in terms of Section 111 of Act 51 of 1977, in the case of the State versus Boyson, Johan Wessel, and 4 others, Rustenburg CAS 1090 of 2009. This one is signed by Advocate, it's the name of Advocate Noko Mashilo appears on page 00859 as the acting DPP KZN, but it is PP signed by, the name appears to be S. Maema.
Is there anything sinister that Maema should sign on behalf of Noko Mashilo? Advocate Noko Mashilo?
Well, it shows that the DPP KZN has not signed the centralization application, and it's signed by the leader of the prosecution team in the Boyson matter. It also appears to be after the centralization was, if I just page back, after the initial centralization application by Advocate Chauke, it appears that this relates to the same issue, but it's now made by ostensibly the DPP of KwaZulu-Natal.
This application was a fresh application by Advocate Noko Mashilo to Advocate Jiba, not so?
That is correct.
Was there a need for this application?
On the face of it, there would not have been a need for it. Well, if the original application was, the person making the application had the authority to do that. That is Advocate Chauke. But it appears that, I'm not sure if there's some correspondence about this, but we must check our documentation about the fact that the centralization application needs to be in the name of it needs to be made by the DPP having authority in this matter, which would be the DPP KwaZulu-Natal. And so it appears that this one is meant to correct or certainly create the impression that the DPP KwaZulu-Natal is the one that is applying for centralization. It is signed, as I said, by the leader of the prosecution team, Advocate Mayema.
Now, if you go to page LO00860, therein you will find another consent to consolidation of charges by JJ Smith SC. Are you there? This consent to consolidation of charges, if you compare it to the previous one on page 854, are they similar?
What are you comparing, Council? What are you comparing?
Comparing the consent to consolidation by Advocate JJ Smith, dated the 2nd of August 2012 on page 00854, in which he was responding the application by Advocate Chauke with the one dated 20 August 2012 on page 00860, in which she was responding, presumably responding to the application made by Advocate Nokumashilo.
Looking at the two documents, they appear to be on the face of it identical, except for the date, which is the first one being the 2nd of August, and the second one being the 20th of August, and the person to whom it is addressed, the first one being to Advocate Chauke, and the second one being to Advocate Noko Mashilo.
Please read it into the record for completeness' sake.
It's on the letterhead of the National Prosecuting Service, Director of Public Prosecutions, Northwest. It's addressed to Advocate M. Noko Mashilo, the Director of Public Prosecutions, KwaZulu-Natal Division, Private Bag X9008, Pietermaritzburg 0300. Dear colleague, consent to consolidation of charges in terms of Section 111 of Act 51 of 1977, the State versus Padiachi and others, Cato Manor Project, Rustenburg, CAS 1097 of 9/2009. I've perused your application for centralization of charges arising out of Rustenburg CAS 1097 of 9/2009 and the copy of the indictment which took place within my area of jurisdiction. I have no objection that the charges mentioned in counts 31 to 34, namely count 1, housebreaking with intent to commit murder and murder, count 2, contravention of section 3, count 31 is the first one, count 32, contravention of section 3 of the Firearms Control Act 60 of 2000, count 33, contravention of section 90 of the Firearms Control Act 60 of 2000, and count 34, defeating or obstructing the course of justice, be dealt with in a single trial together with racketeering charges against all the accused within the area of jurisdiction of the KwaZulu-Natal High Court against the following accused: Gonesegrin Padiachi, Paul Jonathan Mostert, Neville Eva. I'm persuaded that it will be in the interest of justice to centralize the prosecution in terms of Section 101 of the Criminal Procedure Act 51 of 1977 in the High Court for KwaZulu-Natal in one singular trial, in brackets on charges including racketeering in terms of the POCA Act 121 of 1998, close brackets. I accordingly hereby consent to the prosecution of all cases in the area of jurisdiction of the KwaZulu-Natal High Court. Kind regards, JJ Smith, SC, Director of Public Prosecutions, Northwest Division, and appears to be signed by him.
The document will later be handed up as an exhibit. Now proceed to page 00862, wherein you'll find an internal memo from A. Musing. We proceed to read that document into the record.
This is an internal memorandum on the letterhead of the Office of the National Director of Public Prosecutions from A. Mozing to Advocate Njiba, acting ANDPP, subject State versus Boyson and others. The date is 27 August 2012. Subject line, application for directive in terms of Section 111 of Act 51 of 1977, as amended in Section 44 and read with Section 22(3) of Act 32 of 1998. Moved and signed in the above matter committed within the area of jurisdiction of the DPP Northwest. However, the application was erroneously submitted under cover of the letter from the DPP South Gauteng instead of the DPP KZN. A new request has now been submitted under cover of the attached letter from the DPP KZN dated 20 August 2012. It is requested that the acting NDPP issue a new centralization directive as per the attached draft. It is notable that the consent from Advocate Smith SC, is directed to the DPP KZN, the facts otherwise unchanged. The omission is regretted. Kind regards, signed Advocate A. Mozing, Head Special Projects Division, Office of the NDPP.
Do you have any comment about this?
In
this
my
memo?
view, given the evidence that is present and that will be presented, it appears that there was a recognition that Advocate Chauke, not having jurisdiction in this matter, ought not to have applied for the centralization in the first place, and that a fresh application was made, in my view, in order to create the impression that the DPP KZN was in fact requesting this, when we're aware that given the original approval, consent by Advocate Smith, that the original request was made from Advocate Chauke himself. That's as far as I can take it.
Now go to 864, 00864, where there's a draft direction in terms of Section 111 of the Criminal Procedure Act. You see that?
I do.
Go to the next page, 865, 00865. The document is signed in Pretoria, at Pretoria, on the 27th day of August 2012 by Advocate Njiba.
That's correct.
Does it suggest that Advocate Njiba therefore went through this process again from the time that Advocate Chauke applied to the time when Advocate Nogo applied?
It appears to be the case.
You may proceed, Counsel.
Thank you, Madam Chair. I do not have a watch. I rely on my colleague here. There's still time.
It is 11 o'clock. It is 11 o'clock. We will take a tea break at 11:15.
I refer you to LO1 00340. Legal opinions on page 340. LO2. It should be LO2. You will see Advocate Batohi. Are you there? Are you? LO2, it's Advocate Musing's affidavit, which served before the Zondo Commission, State Capture Zondo Commission.
That's correct.
Go to paragraph 110. '98, no? 98, I'm told.
It's 95.
Yes. Yeah, 95, yeah, you're correct, 95. Go to 95 before you go to 96. It's on page LO00376. Can you read that paragraph into the record?
At paragraph 95, Advocate Mosing states,
I beg your pardon. Are these two paragraphs, were they not read into the record earlier?
I don't remember them being read, but
these relate to the racketeering authorizations, Chairperson, so it might have been.
You remember we dealt with racketeering authorizations earlier, and these paragraphs were referred to. I just don't want us to burden the record by repetitions. But if you wish, you may proceed in the event it was not read in. I've made a note on my volume that part of the record, paragraphs 95 and 96.
yeah, I now recall, Madam Chair, it has been dealt with yesterday. At the moment, the relevant one that has to be referred to is paragraph 98.
You please take instructions. I see the advocate behind you is trying to advise you. The lady on the extreme right.
Thank you, Madam Chair. Thank you, Madam Chair. I'm advised it's 98, the relevant one that we need to refer to now.
Not 95. and
Not
90.
95. 95 and 96 have been dealt with yesterday.
Yes.
Thank you, Madam Chair. Advocate Batohi, are you at paragraph 98?
Yes.
Please read it into the record.
At paragraph 98, Advocate Mosing states, on 17 August 2012, JIBA approved 2 applications and issued authorizations in terms of Section 2.4 of POCA in respect of contraventions of Section 2.1E and F of POCA, as well as in terms of Section 111 of Act 51 of 1977, read with Sections 44 and 22.3 of Act 32 of 1998. Subsequently, Myanmar approached me and advised me that the application for centralization was erroneously submitted under cover of the letter from DPP South Gauteng instead of the office of the DPP KwaZulu-Natal. Myanmar then submitted a new application from the correct office. This application was approved by JIBA on 27th August 2012.
It is correct to mention that Advocate Maema is an advocate under the leadership, was an advocate under the leadership of Advocate Smith's SC Northwest.
It is correct, Madam Chair. May I take instructions?
When you confer with senior counsel behind you, switch off your mic because everything will be recorded or picked up by the media there. It will confuse our record.
Thank you, Madam Chair. I'm informed that at the time when he signed the application on behalf of NUCO, he had been assigned from Northwest Division.
Advocate Maema.
Advocate Maema, yes. He was ordinarily within the jurisdiction of Advocate J.J. Smith in the Northwest Division. But at the time, he was one of the members, he was leading the team, the Katumana team, at the time when he was signing the centralization application.
Advocate Maema was the lead counsel in respect of the prosecution of the Katumena team,
Indeed, Madam Chair.
or by the Katumena team, prosecutorial team. It is good to place that on record. Thank you.
May we adjourn at this stage? I just want to align certain aspects, Madam Chair, before I proceed with Advocate Patohi.
Please give me a second. Thank you, Advocate Mhlamunyane. It has been brought to our attention that the maintenance team will need 30 minutes to work on the air conditioning, and therefore we will adjourn for 30 minutes until they deal with the problem.
Madam Chair, knowing maintenance people, at least 30 minutes.
Advocate Greg Toby, 30 minutes. I suspect that you need more than 30 minutes to attend to something. We will take 30 minutes until further notice, Council. Thank you. We will adjourn for tea. Good afternoon, everybody. Advocate Mutlamunyani, you may proceed. I am told that the air conditioning has been attended to, and I hope that at least the one next to you, Advocate Batoy, is functional. The ones next to us are in the process of being sorted out. You were correct, Advocate Batoy. Advocate Mutlamunyani, you may proceed.
Thank you, Madam Chair. Advocate Patohi, we will now deal with subsequent events that took place after the two racketeering certificates were issued by Advocate Chiba. In this respect, I refer you to your affidavit, page 60, and we'll start with paragraph 145. In paragraph 145, you are saying the Boysen instituted an application in which he sought to review and set aside the racketeering certificates. Maybe as a way of reminding you, the review certificate, rather the review application was instituted on the 30th of April 2013. And Madam Chair, that you can find in the B bundle, specifically the B5, B5 on page B01, starting from page B01334, which contains the notice of motion where Johan Vessel Boysen was the applicant and the first respondent was the acting National Director of Public Prosecutions. The date stamp appearing thereon is the 30th April 2013. The registrar's date stamp and the notice of motion bears a date on page B01339 of the same bundle, B5. I should also mention, Madam Chair, that what we are now dealing with would have an impact on the terms of reference, specifically paragraphs 3, 3.1, 3.1.1, 3.1.1.1, and 3.1.1.3. You may go back to your affidavit, Advocate Katohi.
Council, if we could just check whether 3.1.1.4 might also not be relevant with regard to this evidence. For clarity.
Yeah, it's also applicable. I thought I would mention it at that particular time, but you are correct. It's also applicable. Paragraph 3.1.1.4 is also applicable. Thank you. You may then proceed with your affidavit and continue.
So at paragraph 145, Boyson instituted an application in which he sought to review and set aside the racketeering certificates. In this application, he alleged, in brief, that after receipt of the indictment, he requested Jiba to make available, Advocate Jiba, to make available all the documents on which the state intended to rely in this case. As a result of this, the 23 dockets were made available to him. In his affidavit, in this review application, he said that he is mentioned in only 2 of these 23 dockets. In one of the 2 dockets, he's mentioned in the statements of 2 witnesses. Both witnesses stated that he arrived on the scene of a shooting in a helicopter after the event. And in respect of the other docket, the second docket, according to Boyson, the witness states that he noticed Boyson on the scene of a shooting after it had taken place. So that was just a portion of his review application, the affidavit.
Now, let me then hasten to take you to Advocate Musing's affidavit, which you can find in LO2 bundle.
Page number?
Page LO00382. Go to paragraph 110 and read that paragraph into the record.
The section is headed Boyson's review application. May I proceed, Chairperson?
Hang on a bit.
Affidavit of Advocate Musing.
It is the affidavit of Advocate Musing, Madam Chair. which starts on page LO 00340,
382. Because you referred us to 00382.
on which section, rather paragraph 110 appears. But the affidavit itself starts from from page LO 00340, which served before the State Capture Commission. I think we've already mentioned, but it is also appropriate to mention it again.
And it's your paragraph 100 of Msing,
110, 110,
110.
yes, on page LO 00382.
Thank you.
Advocate Patohi, may you proceed to read into the record paragraph 110, which we later hand in as an exhibit.
Sure. The section is headed Boyson's review application. Paragraph 110. The prosecuting team, led by Chauke and I, consulted with Advocate Lawrence Holders SC, in brackets Holders SC, and Advocate Manaka, in brackets Manaka, on the 4th of June 2013, for the purpose of opposing the review application. Holders SC was provided with the prepared notes, the prosecution memorandum, the indictment, and copies of the dockets to enable him to prepare the opposing papers. Should I continue?
Yes, continue to 111.
Paragraph 111, Chauke was of the view that the prosecution memorandum should not be made available as it was a privileged communication between the NDPP and the DPP, to which I agreed.
Now let's go to LO3.
Before you proceed, Counsel, we were earlier informed that Advocate Maema led the prosecution team, which is correct. Advocate Musing seems to suggest that the leader of the prosecution team was Advocate Chauke. Elsewhere, we are told the leader of the prosecution team was Advocate Maema. Please clarify that discrepancy, what appears to be a discrepancy to me.
Let me find out from the witness herself if she's in a position to clarify that.
Yes, thank you. This matter was dealt with at one point in my testimony, explaining that Advocate Chauke was on the evidence that we're presenting, the DPP, the de facto DPP in charge of the team. Advocate Maema, as I explained, in all cases, you would have a DPP who's the head of the division, who would be in charge of matters, and you would have a prosecuting team, the technical level, where you would have a leader at the technical level. So there's no contradiction. It's in fact explains different roles with regard to, for want of a better word, the leader at the technical level and the DPP as the overall person in charge of the team and the prosecution. So there's no contradiction, it's different roles.
We do know that Advocate Chauke was appointed as a coordinator. Will he be falling under that technical team that you are talking about?
In my understanding, Chairperson, he was the DPP in charge, not just my understanding, what Advocate Jiba says in her affidavit, that he was the DPP in charge. So my understanding would be he would not fall in the technical team. The technical team would be headed by Advocate Maema, and the DPP in charge overall of the matter is Advocate Chauke.
As a leader of the prosecution team,
That is correct, Chairperson.
will he then be associated with the prosecutorial decisions that would have been taken?
That is correct, Chairperson.
Thank you.
Thank you, Madam Chair. Let me then refer you to bundle LO3 on page LO 00738. In which you will find an internal memorandum from the Office of the National Director of Public Prosecutions. Please read this document onto the record, and it will later be handed up as an exhibit. Read the purpose, the background, and I'll direct you to where you should read under discussion on the next page in paragraph 3.1, and explain the purpose of this memorandum.
Chairperson, this is a memorandum on the letterhead of the NPA, and specifically the Office of the National Director of Public Prosecutions. It is an internal memorandum from Advocate Amo Singh to Advocate Jiba. The subject line is State versus Boyson and others, Cato Manor case, and the date is the 4th of June, 2013. The purpose of this memorandum is to inform the acting NDPP of the outcome of the meeting consultation with appointed counsel on 4 June 2013 in Sandton. The background as well, counsel.
The background as well, which is in paragraph 2.1 on the next page.
2.1, the appointed counsel is Lawrence Hodes SC from the Johannesburg Bar. He is ably assisted by Advocate Manaka, an African female from the same bar council. The purpose of the meeting was to brief counsel fully on the application of the above case. Present was Advocate Chauke, who led the entire prosecution team, barring Advocate Matendwa, who was on leave. The team had prepared notes for counsel in reply to the points raised in the founding affidavit. In addition, the prosecution memorandum, indictment, and memorandum written by the applicant in support for the payment of rewards for himself and the rest of the accused for work done during the killings was also made available to counsel. The last piece of evidence is, in counsel's view, very important to overcome the application.
Go to discussion.
Document marked AMC 7. Advocate Musamuyana, or MC 7. Yes.
Can't see.
The memorandum.
Or the memorandum.
Yes. What is it? Is that AMC 7 or MC 7?
I don't see, in the copy that is in my possession, I only see it marked D1 in quotation
Give me the
marks.
top page, LO.
LO3, LO 00738. It starts there. But the copy that is in my possession has a handwritten marking of D1 in
It is LO3
LO
00
00738.
738.
Indeed, Madam Chair.
Please refer us to the full numbers. 00.
The full numbers are
00. Count those 00s because we are getting confused.
there are two on the one that I have.
LO3,
It's LO, and then thereafter comes 2 zeros, 00
is volume 3,
in LO3. Yes, volume
738.
738, Madam Chair.
Is this the internal memo by Advocate Musing to Advocate Jiba?
That's correct, Madam Chair.
Thank you, sir.
Go to the next page, 739. Advocate.
Maybe you can take us back to that paragraph, the earlier paragraph that you were reading from.
Should I read the paragraphs again, Council?
Just a minute. Maybe let me understand,
Yes,
Madam Chair. You want me to
which
take
which paragraph did you refer her to of this memo? Where you said he spoke about informing Advocate Jiba of the purpose of the Santon meeting. The purpose appears on the opening page.
It appears on the opening page, Madam
And
Chair.
did you proceed to any other paragraph?
Yes, we proceeded to the background in paragraph 2,
Yes.
and specifically 2.1, which appears on the next page. And then she read into the record the whole of paragraph 2.1.
Yes, thank you.
Perhaps it would be prudent at this stage, we should cross-reference back to Advocate Patohi to Musing's affidavit, paragraph 110.
Can you take me to the affidavit? The reference, please, Council.
LO2, which you read into the record earlier, on page LO 00382, specifically paragraph 110. There.
That will be paragraph 110 of Advocate Musing.
Of Advocate Musing's affidavit.
Yes. Thank you.
I want us to tie the two together. The purpose of this memorandum was to inform the acting NDPP of the outcome of the consultation that took place on the 4th of June. Not so?
Well, the
purpose of-
memorandum is dated the 4th of June,
Yes. Now,
and the meeting was also on the 4th of June, 2013. That's correct.
so it ties with paragraph 110 of Musing's affidavit. Do you agree?
Yes, this paragraph 110 also refers to the meeting of the 4th of June, 2013.
Let us proceed. Go back to the subtopic discussion in paragraph 3 on page 00739, LO 00739 of LO3 bundle. Are you there, Advocate? You will see that towards the end of paragraph 3.1, Musing says the relevant Rule 53. Can you read that into the record, where the sentence starts with the relevant Rule 53?
Certainly, the relevant rule 53 was consulted before we came to the conclusion. Advocate Chauke was adamant that the prosecution memo to the ANDPP is a privileged communication between prosecution between the prosecution and not open for disclosure. I agree with this viewpoint.
The prosecution memorandum referred to herein is the one dated 15 August 2012, not so?
I don't have it before me, so I can't confirm that. I need to check that before I confirm it.
We will find the page. I'm just trying to locate the page, Madam Chair. I remember we dealt with it. I've located it, Madam Chair. It's the memorandum on page LO 665. LO3 bundle on page LO 00665, which was dealt with, I think, yesterday, where Advocate Chauke had signed a memorandum apparently prepared in the name of Advocate Nokomashilo. You might want to comment, maybe, about this memorandum.
Yes, this is certainly what we've been referred to now at 665 is the covering memo signed by Advocate Chauke in the name of Advocate Noko. But on page 668, you will note that the prosecution memorandum is then apparently attached. And in fact, not in fact, but the covering memo refers to the application, the indictment, and the draft authorizations on paragraph 665. This is a prosecution memorandum which appears to be attached. And I cannot say for certain, but it's certainly, that is the prosecution memorandum in the Boyson matter that was prepared by the team. And it would appear that that is the document that is being referred to.
Mutlamanyani, you'll see we have so many bundles in front of us. You simply refer to the pages and we battling to figure out whether it is volume 2 or volume 3. If you can, for the completeness of the record, refer to the volumes that you are talking to.
I thought I was doing that, but my apologies if perhaps I missed.
This
But
will
let me-
be volume 3, LO 00665. 665.
Yes, the memorandum referred to will be the one dated 15 August 2012,
Yes.
will be in bundle LO3 on page LO 00665.
Thank you, sir.
Any other one that I need to refer to as a bundle?
Advocate Mhlamiani, you referred us to LO3, page LO 00665. But Advocate Batohi, your witness, then took us to LO 00668. Which one should we go to?
Let me do it this way. She was taking you to LO 00668 to point out where the prosecution memorandum referred to is located. It starts on page 00668. The covering minute is dated 15 August 2012, which was the application for authorization in terms of Section 2.4 of POCA.
Earlier on, Council, you referred us to page 145 and subsequently to LO 2000382, that is Advocate Musing's document, affidavit, 110.
Let me make a correction, Madam Chair, with respect. It's supposed to be paragraph. I actually referred to paragraph 145 of Advocate Batohi's affidavit, where she starts giving evidence on the review application, the poison review application. It's actually paragraph 145 on page 60 of her affidavit.
What was the point of you referring us to paragraph 145 of her affidavit, and which you read
So that
together, I beg your pardon, let me finish, together with LO 2000382 of Musing, Advocate Musing, that you referred us to? What is the import of all this?
LO2.
Yes.
The import is that in Musing's affidavit, specifically in paragraph 110, he talks about the team led by Advocate Lawrence Holders SC to oppose the team which was set up by the National Director of Public Prosecutions. The team which was set up, let me not say National Director, but the team that was set up by the NPA to oppose the poison review application. Now, this ties with Advocate Musing's memorandum. Advocate Musing's memorandum.
No, I beg your pardon. Paragraph 110 does not speak of Advocate Holders being the leader there. It simply says that the team led by Chauke, not Holders.
Yes. He was stating that they've consulted with Advocate Lawrence Holders. I beg your pardon if I said led by. The advocate who was briefed to oppose the application by Boysen was Advocate Lawrence Holders SC.
It is important to get these things correct, Council, please, because we are recording what you are asking the witness and telling us. It must tally or correspond with the contents of the affidavit. So the point that you were answering earlier was that the import of paragraph 110 of Advocate Musing is the fact that the prosecution team was led by Advocate Chauke.
Indeed, Madam Chair, and that it was Advocate Lawrence Holders who was briefed, with whom consultation took place.
Yes, thank you. Proceed, Council.
Thank you, Madam Chair. Let me refer you then to the supplementary opinion of Dr. Broughton, specifically in LO1.
Council, sorry to interrupt you. Are you done with LO3 00665 and 00668? Because that's the last page that I have in front of me.
I thought I was done, Madam Baloimere, because the witness had indicated that there was a prosecution memo and reference was made to 665 and 668. 665 being the covering minute and 668 containing where the prosecution memorandum begins.
Thank you.
You were referring to the legal opinion of Dr. Broughton
Yes,
when my
which,
sister asked you a question.
yes, Madam Chair. Go to LO1, Advocate Batohi, and go to page 00217. Go to paragraph 137, and can you read it into the record?
At page 137,
Paragraph 137.
paragraph 137, it is noted that in Advocate Chauke's email to advocate holders dated 17 March 2014, which would be annexed to you to Advocate Broughton's supplementary affidavit, it's in the bundle, which we can have a look at, where Advocate Chauke suggested to counsel how the application for leave to appeal in the Boyson review case was to be handled. Advocate Chauke intimated that, open quotes, counsel should also place more emphasis on the fact that Boyson made a memo of rewards indicating his direct involvement. This is an indication of Advocate Chauke's knowledge of the case.
This suggests that
I beg your pardon. It is your testimony that this paragraph or this piece that we have read into the record signifies Advocate Chauke's knowledge of the case.
Of the facts of the case as opposed to just being a coordinator. It's one of the pieces of evidence that will indicate his knowledge of the evidence in this matter.
It signifies him having knowledge of the case as opposed to his involvement in the decision-making processes relating to the case.
That's not what I'm saying, Chairperson. What I'm
No,
saying,
no, I'm asking you a question.
Chairperson, no. It signifies his knowledge of evidence in this matter as opposed to his assertion that he was a mere coordinator, which would seem to convey the impression that he was not deeply involved in the case itself with regard to the prosecution and the evidence, etc.
A follow-up question, Counsel. Is there anything wrong for a coordinator or a liaison officer to read and know what they are coordinating, to know the contents of the files?
I say it in the context of Advocate Chauke's assertion that he was a mere coordinator, which suggests that he was, and he set out what his role entailed. It seems to convey the impression that he was not involved intimately with the investigation and the prosecution of this matter. So what I'm saying is that this is one indication that that is not correct.
If memory serves me well, the only exclusion from his duties was making prosecutorial decisions. But I don't think, or I didn't see anywhere where he was excluded from knowing the facts or from reading the files.
Perhaps I can address it in this way. A decision to take a matter on appeal is also a prosecutorial decision. So in this case, Advocate Chauke's role in this process, in terms of his engagement with Advocate Hodis regarding appealing this matter, would amount to a prosecutorial decision with regard to the appeal process in this matter.
Going back to my question. Thank you, my sister, to piggyback on that. So this extract that you have read to us and repeating your answer is not only about him having knowledge about the appeal. It also signifies, according to you, that he was involved in the appeal decisions.
That is correct, in the decision to take the matter on appeal.
On was your contrasting knowledge of the appeal matters with him having been a coordinator. Are you correct in that?
That is, let me think about that before I agree too quickly. Should go back to what he says his role was as a coordinator so that I can properly apply my mind to that.
No. You see, the extract that you have read to us or read into the record speaks of Advocate Chauke having made suggestions to the lead counsel in the appeal. And I asked you the question as to whether his involvement in the appeal, as you read into the record, is suggestive of the fact that he participated in the appeal decision making.
That is correct.
And your answer was that no, it signifies that he had knowledge of the appeal processes, if I may paraphrase, but you spoke of knowledge.
Chairperson,
if I may proceed, ma'am, and just clarify my question to you, but you may answer if you are in a position to answer.
well, I'm trying to, because there's a number of things that were asked with regard to this piece of information. Perhaps what I can say is that this piece of information, together with others, will indicate Advocate Chauke's involvement in the appeal process and in taking a decision to support or to request an appeal in this process, which in fact would be contrary to what he says his role as a coordinator was, because it excluded taking prosecutorial decisions, and deciding to take a matter on appeal is a prosecutorial decision. I hope that clarifies, Chairperson.
Yes, it does clarify. And I asked you a question. Are you correcting your earlier answer that necessitated our questions? Because you seemed earlier to be contrasting knowledge of the appeal process with him having appointed as a coordinator.
Chairperson, sorry.
The question then was, are you then therefore correcting your earlier answer?
Chairperson, I don't think I made a mistake. I think we need to read the record so that I think I dealt with one aspect of it and then dealt with another aspect of it. But I don't think that I made a mistake that requires a correction, but I would like to look at that.
Advocate Mutlamunyani, as your witness, you can assist him.
Let us for now proceed. I refer to paragraph 137 just to indicate the extent to which Advocate Chauke participated in the whole poison issue.
137 and LO1 is that?
Yes, LO1, yes. But now, I want to take you back to your affidavit. Let's park the issue of the appeal for now. I want to take you back to your affidavit. Go back to page 61.
I'm there.
May I proceed, Madam Chair?
You may proceed, Counsel.
Go to paragraph 146.
Mm-hmm.
Deal with the JIBA answering affidavit.
So in response to Boyson's founding affidavit, in the review process, Advocate Jiba deposed to an answering affidavit. This affidavit was, according to Advocate Chauke himself, finalized by him. In her answering affidavit, and in response to Boyson's assertion that no statements in the dockets implicated him.
Advocate Mutlamunyani, I'm really sorry to interrupt your witness. At paragraph 146, there is a footnote there.
Yes, there is a footnote,
The
Madam.
footnote tells us that it's Advocate Chauke's confirmatory affidavit in the GCB matter and filed under Bundle Zondo Commission. The witness gave another explanation that in response to the Boyson's matter, Jiva deposed to an affidavit that was finalized by Chauke. Can we maybe be guided to that affidavit if it's close by in the Boyson's? Because I heard Boyson in response to Boyson, but when I look at the footnote and read what is on the footnote, it doesn't talk about Boyson. Instead, it gives me Jiba against the GCB and also that it was filed in the Zondo Commission. And unless if I'm misunderstanding the explanation.
Maybe let us go to the footnote itself and go to ZC 00164.
In which bundle, Counsel?
ZC 00184 to ZC 00165. I'll get the volume soon. Volume 1, Madam Baloy Mere.
The confirmatory affidavit of Advocate Chauke.
Indeed, Madam Chair.
I don't
But
see.
it's in the GCB matter. If you look at the head note.
Yes.
May I explain my response?
I beg your pardon, ma'am. Just wait for counsel to capture what we are talking about.
They're still trying to locate for me ZC164 and
Yes, counsel. I beg your pardon, Advocate Batoi.
I don't seem to have the bundle either, Chairperson.
Well, it is your team that ought to have prepared your bundles.
That's great.
I don't.
And by the way, Advocate Batoi, all these bundles that we have prepared ourselves come from your office.
That is correct, Chairperson. There was a lot of work that went into this.
Maybe to assist, because I'm the one who raised this issue. The witness may have been wrong to characterize paragraph 146 and link it to the Boysen matter instead of just because the paragraph that deals with the Boysen matter starts from 147. But before she read 146, she characterized it as in response to a Boysen matter. That's where my confusion came in, because I looked at the footnote, and the footnote doesn't say anything about Boysens.
in fact, it's cross-referenced in LO. It must be LO2.
Chairperson, I did ask if I could try to clarify the panel members' confusion. I would appreciate the opportunity to do that.
I think you must wait for your counsel to lead you. He is still trying to find himself, and please allow him to lead you. Because if he doesn't understand, then it will be difficult for him to lead you. Just be patient a little bit and let counsel take us through what we are trying to ascertain.
Madam Chair, Nomno Advocate Jibas affidavit appears in bundle LO3. And it is paragraph
Page number,
Page.
please.
page LO00871. Now, it might be prudent to also refer to 210 before we get to 211. Without being seen to be repetitive, Advocate Matohi, I would ask you to please just read 210 again, paragraph 210 of that, before you get to 211.
Paragraph 210. Following the consultation, the prosecution team agreed that Advocate Chauke, as the DPP in charge of this matter, would be the liaison person between Advocate Hode's SC team and the prosecution team, and would provide the Hode's SC team with all the facts and evidence in the dockets necessary for the prosecution team to prepare an answering affidavit to be deposed to by myself on behalf of the NPA.
Yes, proceed. Read the whole sentence. The whole paragraph, rather.
Pardon me. I refer the court to the confirmatory affidavit of Advocate Chauke filed herewith.
We'll go to it. Just go to 211.
The Hodes team then prepared the answering affidavit, which was finalized by Advocate Chauke and which I signed. It was then duly filed by State Attorney. At the time that I deposed to the answering affidavit, the facts and the evidence against Boyson had been presented to me on many occasions, and I was well acquainted with the case against him.
Yeah, it will later be handed up as an exhibit. That page 871 in bundle LO3. But then let us now go to the confirmatory affidavit of Advocate Chauke, which you will locate in LO4 bundle. Are you there?
Page number?
880. It starts on page 880.
880.
Yes. Are you there?
Not yet. I am.
It's a confirmatory affidavit of Andrew Chauke. Confirm that.
That is correct.
Mr. Counsel, just give me a second.
$880.
In paragraph 210 that you have just read into the record, where mention is made of Advocate Chauke having been the DPP in charge of this matter. Which matter?
May you answer the question of the chair?
Of the Boyson, my understanding is it's of the Boyson prosecution matter.
But the matter in respect of which the affidavit is prepared is the GCB matter against Advocate Jiba, Advocate Mrebi, and one Mzinyati, which was not necessarily a Boyson's matter. So I just want to get clarity there.
Yes, I'm trying to give clarity, Chairperson.
Yes.
If I'd be given the opportunity to explain, it might become clear.
Yes, if Advocate Jiba deposes to an affidavit in a matter in which she is a respondent And she refers to that matter in which she is a party. And she says, following the consultation process, prosecution team agreed that Advocate Chauke, as the DPP in charge of this matter,
Chairperson, can I be referred to that page again?
which matter does it refer to? It's a page LO 00871, which is marked an exhibit to be
Sure.
handed up later. Paragraph 210 that you write into the record.
Yes, I'm back there.
Yes. My question is, Counsel, reference to this matter. My question is, which matter? And you say the Boyson's matter. And I refer you to the deposition, or rather to the affidavit of Advocate Jiba, in which she is a respondent. And that matter is not a Boyson's matter per se. It is an application by the GCB. And that's where I'm getting a confusion when you say this matter, in which Advocate Chauke, according to you, was allegedly in charge of, seem to be incorrect. And do correct me if I'm wrong.
Thank you, Chairperson. I appreciate the opportunity.
If I may, to assist her, Madam Chair, with your permission, that may help her to answer the question.
Yes, sir.
May I refer you, with Madam Chair's permission, Advocate Batohi, to paragraph 208 on the same page?
Yes, that's where I was going. Thank you.
Go there.
So let me, I'm trying to figure out how to deal with this so that it makes sense and I'm clear about it. But okay, let's start with paragraph 208. It states, and that is correct, Chairperson, this is Jiba's affidavit in the GCB matter. At paragraph 208, she's now dealing with the Boyson matter. The Boyson matter was instituted and argued at a time when there was still uncertainty as regards the reviewability of decisions to prosecute or not to prosecute. As I have set out above, this was indeed only finally determined by the decision of Branch J in the full matter. The judgment of Gorvin, which was the Boyson review judgment, was handed down on 26 February 2014, and after the judgment of Murphy in the full matter, but before the judgment of Brandt in the JA matter. And these cases will become relevant later in the Luli case. For that reason, the advice of Hoda's SC team was that it was not necessary to file a Rule 53 record. I never intended to detail all of the information that was placed before me for the purposes of granting the authorization. Following the consultation of the prosecution team, the prosecution team agreed that Advocate Chauke, as the DPP in charge of this matter, would be the liaison person between Advocate Hoda's SC team and the prosecution team, and would provide the Hoda's SC team with all the facts and evidence necessary, all the facts and evidence in the dockets necessary from the prosecution team to prepare an answering affidavit to be deposed to by myself on behalf of the NPA. I refer to the court to the confirmatory affidavit of Advocate Chauke filed herewith. So, Chairperson, if I may explain, at paragraph 146, going back to my affidavit at page 61,
Yes, ma'am.
Chairperson, I state in response, Jiba deposed to an answering affidavit. So she deposed to an answering affidavit in the Boyson review matter.